Good morning, everybody. Good morning. Welcome. Good morning. Hello, hello. Welcome in. Welcome in. We've got some stuff to do. Hello, Nani. Hello. Welcome. Hopefully, everybody can. Boy, I tell you what. Good morning, Tootie. I tell you, I am struggling a little bit getting my new setup working here. So, hello, Steffi. Duchess. Hello. Welcome. Good morning. Hello. Hello, Isabel. Willie B. Hi, hi, hi. Just mom to three. Wow. That's not just mom. That's like super mom. Nice work. Good morning, Arlene. Hello. Hello, hello, everybody. I have some documents to catch us up on here. So I'm only a couple days behind, but there's so much stuff going on. It feels like I'm extremely far behind. So trying to be careful. Good morning, legal boxers. Good morning. Oh my goodness gracious. Well, hello, hello. So this morning, I know there's a lot going on with the Department of Education, everyone, and I do have I do have everything put together, but I just can't bring myself to do it this morning. I'll do it later. So I will be going through the Department of Education stuff, but later. We're gonna start with a bit of a different document here. Good morning. I hope we can put out the dumpster fire. Everybody, bring water. We need water. Oh my gosh. Yeah. So this morning, though, what I wanted to do was take you through the California case that was decided July 11th, where we have actually probable cause and reasonable suspicion that is needed in order to detain someone, which has been required since the 60s, I think. It seems like not that long ago, but it actually was. You got time to read. Oh, I love it. I love it. Hello, Brenda. So, as a lot of you know, my background is in primarily in criminal law. That was one area that I spent a lot of time in. I've also, of course, done civil and administrative work, but have the most stories to tell about criminal and evidence. So, 56. Oh my gosh, congrats. Oh, I love it. I love it. I love it. So today I thought, well, let's go ahead and talk about what we've got going on here in this case. So this was a California case. It hit the news pretty good last week regarding in California whether or not you can just pull people up off the street. So there was some misunderstanding here. Yeah, there was some misunderstanding regarding the language that was being used. I think one of the things this administration struggles with, in my humble opinion, is keeping the inside thoughts like inside your head. Like there's a reason they're in your head and people don't say them. Like there's a reason. And that continues to be an issue here. Landlord tenant personal injury. Hey, yeah, that's a lot. That's a lot. So this is one of those situations where, just going about flapping your whatevers, talking about whatever's you want, is going to get you into some trouble. So here we go. They're walking intrusive thoughts. True, true, true. So this is the Perdomo case. Let me put this on here so we have it written out. Perdomo versus Noam here. And here's our case number. We are in California, so that's, that seems to be right now the hotbed of where a lot of lawsuits are being filed against the state of California. I did a post just a couple days ago about the federal government suing them because of their, egg laws, I guess, whatever. So that's happening. There's just a lot going on. They seem to really be going after the California at the moment, which, I don't think is particularly surprising. I don't think, but thoughts are for thinking, words are for speaking. So true. True, true, true. A party in the city. Oh my gosh, VC, yes. Oh my goodness gracious. All right, but there are, again, a few truths that even they cannot get around here. And one of them is how we treat picking people up, right? So reasonable suspicion, which I'm probably going to spell wrong, suspicion here, and probable cause. And these are standards of proof here. Hold on, that's an O. Probable cause. These are required by the Fourth Amendment to the U.S. Constitution. So these aren't just like, oh, for funsies. These are actually requirements under the Constitution that have to be met in order to deprive someone of their liberty of movement, right? So because of that, there are certain standards that we use. Now, I think a lot of people have kind of come in this situation and said, well, it's administrative, and so we can kind of do what we want. That's just not how the Constitution works. If the government's involved and something is restricted, and that can be life, liberty, property, then that means the Constitution is in play, and you have to follow the rules. Even if we're talking about civil situations. What's happening with these jerks today? Good morning, Murray. All right, everybody, don't mute Murray, all right? And yes, we're having cube issues, so I thought, let's just go through this case. I haven't had a chance to really crack it open. So again, because I have worked in criminal law throughout my entire career, that was one area that I did not want to work in, but you know, you just kind of go towards the areas that you're good at, apparently. So it wasn't by choice. So I thought, let's talk about it. Let's talk about the standards here. So let me go ahead and dive in, everyone, to this case. Again, this is the California decision that came out July 11th. Let me put that date on here so we know that we're okay here. This decision has been appealed, so we will have to wait and see what happens in the Ninth Circuit, but so far so good. Here we go. On June 6th, federal law enforcement arrived in Los Angeles to participate in what federal officers have described as the largest mass deportation operation in history. And looks like she's going to put the citations down here. The individuals and organizations who have brought this lawsuit argue that this operation had two key features, both of which were unconstitutional. Roving patrols indiscriminately rounding up numerous individuals without reasonable suspicion, that's required under the Fourth Amendment, and having done so, denying these individuals access to lawyers, which is under the Sixth Amendment. Let's just write out our amendment violations here. Okay, there we go. Who could help them navigate the legal process they found themselves in. On this, the federal government agrees, so we have some stipulations here. Roving patrols without reasonable suspicions violate the Fourth Amendment to the Constitution, and denying access to lawyers violates the Fifth Amendment to the Constitution. Now, I've put the Sixth up here, so let's just clarify this. We've got due process under the Fifth, but let's see how they're moving this around here. All right, there's the articles, there's the amendments. Let's just make sure, right? In a criminal prosecution, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have their assistance of counsel for his defense. So that's where I'm coming from, everyone. But the key here is, of course, this is a criminal case. So because we are in civil world, that's why we're bumping up to the Fifth Amendment. All right. So the Fifth Amendment, most important piece, of course, is, here we go. Shall actually service in time, nor shall any person be subject to the same offense twice. Compelled a criminal case be right, nor be deprived of life, liberty, or property without due process. So it's the due process clause that we're looking at, the federal due process clause of the Fifth Amendment. All right, that's important. I need to put that into my head because so much of our immigration is presented as criminal or crimmigration, I think it's important to remember that it's not. And that Sixth Amendment right to counsel piece is for our criminal cases. So that's really important. That's a moment of learning for me, everyone. Mexican River. Oh, really? Oh, my goodness gracious. Goodness gracious. All right, here we go. So now that that's clarified, we have the Fourth Amendment and the Fifth Amendment due process clause, and that's because we're in a civil landscape. We have to be careful here. Oh my gosh. Applies to deprivation of life, liberty, or property. Exactly right. Exactly right. All right, so here we go. As opposed to the right to an attorney in a criminal case under the Gideon case. So we are not in the criminal world, even though it feels that way. All right, amendment to the Constitution denying access to lawyers violates the Fifth Amendment to the Constitution. So that due process clause here, what the federal government would have this court believe in the face of a mountain of evidence presented in this case is that none of this is actually happening. So, egads, most of the questions before this court are fairly simple and non-controversial, and both sides in this case agree on the answers. May the federal government conduct immigration enforcement, even large-scale immigration enforcement, in Los Angeles? Yes, it may. Does the U.S. Constitution only apply to criminal cases? Then it's a civil state-based. Good question. You know, we have kind of a weird situation going on in, with civil cases because we've got that Seventh Amendment piece in there. So, well, I don't know. We're kind of in a middle gray area with our civil cases. Due process is applicable everywhere. So we've got the federal government in play on this case. We got to keep that in mind. Do all individuals, regardless of immigration status, share the rights guaranteed by the Fourth and Fifth Amendments to the Constitution? Yes, they do. Is it illegal to conduct roving patrols, which identify people based upon race alone, aggressively question them, and then detain them without a warrant, without their consent, without reasonable suspicion that they are without status? Yes, it is. It is unlawful to prevent people from having access to lawyers who can help them in immigration court. There are really two questions in controversy that this court must decide today. First, are individuals and organizations who brought this lawsuit likely to succeed in proving that the federal government is indeed conducting roving patrols without reasonable suspicion and denying access to lawyers? This court decides, based on all the evidence presented, that they are. So they are here likely to succeed in a lawsuit proving the federal government screwed up here. All right. And second, what should be done about it? The individuals and organizations who have brought this lawsuit have made a fairly modest request that this court order the federal government to stop. That's it. For the reasons stated below, the court grants their request. Before the court are two ex parte applications for temporary restraining order and an order to show cause regarding preliminary injunction filed by plaintiffs. For the reasons stated herein, the court grants the ex parte applications. Now, ex parte just means only one party is talking to the court. That can come into play. It's unusual. That's the exception, not the rule. When we're in civil cases, criminal cases, both sides need to be present for everything. But there are some exceptions to that, like temporary restraining orders. Here's our background here. A factual background. The court began by summarizing the allegations in the first amended complaint. Petitioner plaintiffs, Perdomo, Osordo, and Molina are residents of Pasadena, California, who were arrested at a bus stop as they waited to be picked up for a job on June 18th. They filed this action while detained in the basement of a Los Angeles downtown federal building. Plaintiff Viramontes is a resident of Baldwin Park, California. He works at a car wash in Orange County, California, that has been visited 3 times by immigration agents, most recently on June 18th, when he was questioned and detained by agents despite informing them that he is a U.S. citizen. Plaintiff Gavidia is a resident of East Los Angeles, California. He was stopped and questioned by immigration agents at a tow yard in Los Angeles County on June 12th, despite explaining multiple times that he's a U.S. citizen. Plaintiff Los Angeles Workers Center Network is a multiracial, multi-ethnic, and multi-industry organization comprised of worker centers and labor organizations that work together to address injustices faced by low-wage workers in the greater Los Angeles area, including immigrant and non-English speaking workers. LAWCN has worker center members who in turn have individual members, including non-citizens with legal status and U.S. citizens. Plaintiff United Farm Workers, UFW, is a farm worker union with approximately 10,000 members, with more members in California than any other state. UFW's members in California work at agricultural sites as well as non-agricultural sites within the district. UFW's members include non-citizens with legal and U.S. citizens. Legal status. Plaintiff Coalition for Humane Immigration Rights, CHRLA, is a nonprofit organization with its principal place of business in Los Angeles, California. CHRLA was founded in 1986 to advance the human and civil rights of immigrants and refugees. As a membership organization, CHRLA has approximately 50,000 members across California, including both U.S. citizens and non-citizens of varying immigration status. CHRLA has members in every county in the district. Plaintiff Immigration Defenders Law Center is a nonprofit organization having the principal place of business in Los Angeles. Besides Los Angeles, MDEF has offices in Riverside, Santa Ana, San Diego, California, and works across the U.S.-Mexico border in Tijuana. MDEF was founded in 2015 to protect the due process rights of immigrants facing deportation. The court will refer to the 5 individual plaintiffs, LONCN, UFW, CHRLA, as stop and arrest plaintiffs. And that's really important. Not stop and frisk, stop and arrest. The court will refer to the MDEF and CHRLA as access detention plaintiffs. So we got 2 sets here. The court will address all plaintiffs as plaintiffs. So for clarification here. Defendants. Defendant Kristi Noem is the Secretary of the Department of Homeland Security, DHS, which is responsible for administering and enforcing the nation's immigration laws pursuant to 8 U.S. Code Section 1103, Sub A. Noem is sued in her official capacity. Defendant Todd Lyons is Acting Director of the U.S. Immigration and Customs Enforcement. I refer to this group as the Cubes, so I don't get dinged here, an agency of the United States within DHS. The Cubes are responsible for stops, arrests, and custody of individuals believed to be in violation of civil immigration law. Lyons is sued in his official capacity. I think this is interesting. I mean, it sucks that all of this is happening, everyone, but it is interesting for us to start kind of carving out this area of the law. Defendant Scott is the Commissioner of the U.S. Customs and Border Protection, CBP, and the agency within DHS that's responsible for enforcing immigration laws at or close to the U.S. border. Scott has direct authority over all CBP policies, procedures, practices related to stops, arrests, and detention. He's sued in his official capacity. Defendant Michael Banks is the chief of the U.S. Border Patrol. Banks has direct authority over all Border Patrol policies, procedures, and practices related to stops, arrests, and detention. He's being sued in his official capacity. Defendant Kash Patel is the director of the U.S. Federal Bureau of Investigation. In that capacity, Patel's responsible for the direction and oversight of all operations of the FBI. Patel is sued in his official capacity. Pam Bondi is the U.S. Attorney General. Bondi is the head of the Department of Justice, EGADS, and is responsible for the direction and oversight of all operations of the DOJ. Bondi is sued in her official capacity. Defendant Ernesto Santa Cruz Jr., Acting Field Office Director for the Los Angeles Field Office of the Cubes. Santa Cruz Jr. is responsible for supervision of personnel within the cube's enforcement and removal operations. Arrow here. In the geographic area covered by the Los Angeles field office, which comprises the 7 counties in the district and facilities within the district, including B-18 here. The cubes. That's right. Next, we have Eddie Wang, U.S. Homeland Security. Then we have Gregory Bovino, Chief Patrol Agent for the El Centro sector here. Stallnacker, Acting Chief Patrol Agent for San Diego sector here. Kind of skipping through. Yeah, that's an interesting point, actually, Jennifer. After your own people, I think that's such an interesting point. I'm going to pause for a moment to speak on it, and I tell you what, there have been many, many times where I have been in a situation where one person out of a group of people being targeted will say, good for them, targeting them. And my response has always been, there are jerks in all walks of life. So I remember I went to a book group once and was talking about certain groups of people, protected groups of people who were voting a certain way. And someone had said, why would they vote against their own interest? And then again, my response was, because they're jerks. You can be in a protected class and you can be impoverished. You can be any of those things and still be a jerk. So that's always my response. Like there's jerks in all walks of life. Everyone. All right. Here we go. So, and some people are always shocked when I say that. Like, what? I'm like, no, it's a true story. True story. Oh my goodness. It's so many. I know. The sheer quantity is overwhelming. All right. Davis, Assistant Director of the Los Angeles Office of the FBI here. And then Asali, together with other defendants here, that's kind of like an open door here, is U.S. Attorney for the Central District of California. Yes. So number 3, arrests and detentions. VC, is my light flickering for you guys at all? Or are you okay? I'm curious. I had a bit of a flicker problem earlier. Let me know. Are we okay? No, that's right. No, it's not flickering. Okay, thank you so much. All good. Thank you. Appreciate it. No, ma'am. Okay, thank you so much. I appreciate it. All right, here's number 3, arrests and detentions. So now we're going to get into it here. On June 6th of 2025, federal agents detained multiple day laborers outside of the Westlake Home Depot. In the following days, similar raids occurred throughout the district. Car wash workers, farm and agricultural workers, street vendors, recycling center workers, tow yard workers, and packing house workers were targeted. Between Monday, June 9th and June 13th, at least 43 people were detained on farms in Ventura and Santa Barbara counties. Various places have been targeted by federal agents, listing farmers markets, swap meet, bus stops, parks, gyms, and churches. In one instance, the agents approached and prevented a non-white individual from walking away, but not those who appeared to be Caucasians. So as we go through this, I'm using the language the judge is using here, but race is a very sensitive topic, everyone. The term Caucasian is very sensitive. That's a specific area of the world. I understand that. Also, the phrase non-white, that can also be offensive. True, but I'm using the language the judge is using here, all right? In another, the agents arrived in unmarked vehicles, pointed a GUN, and demanded identification without providing a reason for the stop. So that's not okay. All right, that's an escalated moment. Yet, in a different context, the agents provided no reason for stopping individuals at a church. Since they began on June 6th, federal immigration raids have led to the arrest of over 1,500 people. Agents and officers approach suddenly and in large numbers in military style or SWAT clothing, heavily armed with weapons displayed, masks, and their vests, with their vests displaying a generic police patch, if any display at all. Agents typically position themselves around individuals, aggressively engage them, and or shout commands, making it nearly impossible for individuals to decline to answer their questions. When individuals have tried to avoid an encounter with agents and officers, they have been followed and pushed to the ground, sometimes even beaten and taken away. These incidents have been widely reported in the news. Defendants have a policy and practice of effectuating warrantless arrests without making an individualized flight risk determination. That's important for the level of force that's allowed to be used. All right, that's one of the pieces here. Defendants also have a policy and practice of not identifying themselves or explaining the basis for an arrest upon taking someone into custody. So again, this is another place where we're clashing between a civil rule that's being violated versus criminal arrest and custody. Agents and officers often show up masked without any visible badges or insignia indicating what agency they work for and have refused to identify themselves when asked. So by going down this middle road of it being administrative civil, on the one hand, it gives extra power to anyone in that situation, right? So the cubes have this idea that they can do what they want because we don't have criminal rules protecting people. And then on the other hand, they're going at it in a way that looks criminal. So people are saying, well, those 1,500 people were criminals. See how they're getting the best of both worlds? So it's looking like they are arresting criminals because of how they're presenting it. Meanwhile, they're taking power that they shouldn't be using and using it in a civil context. So this is kind of like the best of both worlds for some civil rights violations. Conditions at B18. During the ongoing raids and as an integral part of the policy and pattern of unlawful stops and arrests, defendants have been taking individuals who are swept up to the basement of the federal building at 300 North Los Angeles Street in Los Angeles, commonly referred to as B18. B18 is a facility for immigrant detainees designed to hold a limited number of individuals temporarily so that they can be processed and released or processed and transported to a long-term detention facility. It does not have beds, showers, or medical facilities. Individuals taken to the B18 are being kept in small, windowless rooms with dozens or more other detainees in cramped quarters. Some rooms are so cramped that the detainees cannot sit, let alone lie down, for hours at a time. As of June 20th, over 300 individuals were being held at B18. Yikes. Let's keep in mind other situations where people have been held that way. All right, so we'll just kind of keep that in the back of our minds. Detainees are routinely deprived of food, and some have not even been given water other than what comes out of the combined sink and toilet in the group detention room. Upon asking for food, detainees have been told repeatedly that the facility has run out. Detainees are denied access to necessary medical care and medications. Individuals with conditions that require consistent medications and treatment are not given any medical attention, even when that information is brought to the attention of the officers on duty. On June 19th, an MDEF attorney arrived at B18 to meet with detainees, including one who was scheduled for chemotherapy appointment the next day. Despite showing a doctor's note confirming the appointment and specifying that missing the appointment would be detrimental to the detainee's health, the guards repeatedly would not allow the attorney to meet with the ill detainee. The facility cannot provide detainees with basic hygiene. Individuals who are menstruating have had to wait long periods before receiving menstruation pads. if they receive them at all. So again, when you pull back the curtain, all right, when you pull back the curtain, this has to do with people who are willing to not view other human beings as human beings. That's what's happening here. We've had many situations in the United States where people have viewed other humans as subhumans. And again, these basic pieces here are showing that again. So you might say cruel and unusual punishment, right? But they're going to argue this isn't a punishment. This is a holding situation for a civil violation. So if we're not in criminal court and you've not been sentenced to this as a punishment, the Eighth Amendment isn't going to come in and help you. That's another reason why they get the benefits of everything, because we're in civil administrative land. Denial of access to counsel. Individuals detained at B18 have had their access to prospective or retained counsel restricted. On June 6th, attorneys and legal representatives from CHRLA and IMDEF attempted to gain access to B18 to advise detainees of their rights and assess their eligibility for relief, but they were not permitted to enter. When they returned to B18 the next morning, attorneys identified a handwritten notice on the door of the family and attorney interests of B18, indicating B18 would not permit any visits that day. Federal officers then deployed an unknown chemical agent against family members, attorneys, and representatives. The chemical agent caused everyone to cough and inflicted a burning sensation in the eyes, nose, and throat. That same morning, numerous unmarked white vans quickly departed B18 with a group of detainees. CHRLA and IMDEF attorneys and representatives attempted to loudly share Know Your Rights information with the detainees in the vans. So they were yelling legal advice to the vans as the vans were driving away, right? Federal agents blasted their horns. Why would they do that, right? If they're just telling them information. Yeah, on the rare occasions when attorneys and family members were allowed access to their clients or loved ones, they were made to wait hours at a time to see them, and the resulting visits were limited to a mere 5 to 10 minutes. In many cases, attorneys and family members were unable to determine whether a particular individual is even detained at B18 or whether they have been transferred to another facility or another country. B18 officers have refused to provide clear answers to questions about detainees' whereabouts or refused to answer questions altogether. The Cube's online locator, which provides information about detainees' location, is not updated in a timely manner. The 4 missing people that the UN's looking for, no, they've not found them. The other missing people that the UN is not looking into, that I do not know. I only know about the UN case. How can there be so many terrible people who lack basic empathy? You know, there always has been, everyone. It's that they've been hidden and not discussed and not shown. So, you know, like the cockroaches, right? If they're hidden away in the dark, then you think there's not very many of them. But yeah, there are. And if you've worked within the criminal justice system, you know what I'm talking about. All right, here we go. Officially sanctioned conduct. And this is another piece here. What is it their bosses say are okay? In January, the administration gave Cube field offices an arrest quota of 75 arrests per day. The administration also shut down multiple oversight agencies. The administration set a new arrest quota of 3,000 arrests per day and reportedly threatened job consequences if officials failed to meet the arrest quota. Now, something about arrest quotas that has been argued in multiple lawsuits is an arrest itself is not going to set out enough of an enough evidence to say that this is a bad person or that something bad has happened. And we're also talking about civil law violations as well. So I think that's really important. Some people are saying, right, everyone like to come in and say, well, you can indict a ham sandwich. And here, the cubes, they can arrest anyone. Because if you have, weapons on your person, you can pretty much arrest anyone, right? So that's kind of something to keep in mind with these quotas, is that if you're just trying to fill numbers, right? I mean, who cares if you're a citizen or not? You still get your number count for the day. Individual plaintiffs' experiences. Yes. It's not easy to acknowledge what's happening here, but it's incredibly important that we look at it. We can't look away anymore. Individual plaintiffs' experiences. In the early morning of June 18th in Pasadena, California, Vasquez Perdomo, so the plaintiff, one of the plaintiffs here, was waiting at a bus stop across the street from Winchel's Donuts with several co-workers to be picked up for a job. About 4 cars converged on his location, and about half a dozen masked agents jumped out of either side of him. They had weapons and masks that did not identify themselves. Vasquez Perdomo tried to leave, but was surrounded, grabbed, handcuffed, and put into one of the vehicles. No warrant was shown. It was only after he was brought to a nearby CVS parking lot that agents checked Vasquez Perdomo's identification. Agents did not inform Vasquez Perdomo that they were immigration officers authorized to make an arrest, or of the basis for his arrest. At the time this action was filed, Vasquez Perdomo had been transported to and was being held in B18. There he experienced extremely crowded and unsanitary conditions, was given little to eat or drink, and slept on the floor. In the early morning of June 18th in Pasadena, California, Osordo was waiting to be picked up for work with his co-worker, Vasquez Perdomo, when federal agents approached. He tried to run, but one of the agents caught up to him, pointed a taser at his head, and said, "Stop or I'll use it." Osordo stopped immediately. Osordo was handcuffed and put into a vehicle. It was only after he was brought to a nearby CVS parking lot that agents asked Osordo if he had papers. No warrant was shown. Agents did not inform Osordo that they were immigration officers authorized to make an arrest or of the basis for his arrest. At the time this action was filed, Osordo had been transported to and was being held at B18. The facility was full, and when people asked for help, officers told them there was no food, no water, and no medicine. Today he remains in custody at the Adelanto Cube Processing Center. In the early morning of June 18th in Pasadena, California, Villegas Molina was waiting to be picked up for work with his co-workers, Vasquez Perdomo and Osordo, when federal agents approached. An agent yelled at Molina not to run, even though he was still in calm. He was told to provide his identification and provided his California ID, but the agent kept questioning him. No warrant was shown. Agents did not inform Molina that they were immigration officers authorized to make an arrest or of the basis for his arrest. At the time this action was filed, Molina had been transported to and was being held at B18. He slept on the floor and was given almost nothing to eat. On the morning of June 18th, Hernandez Viramontes was working at a car wash in Orange County, where he had worked for approximately 10 years when immigration agents arrived. During this visit, the agents did not identify themselves. Agents asked Hernandez Viramontes whether he was a citizen, and he replied yes, and explained that he was a dual citizen of U.S. and Mexico. They asked for an ID, which he provided. Agents then explained that his ID was not enough because he did not have his passport. They were taking him. Agents placed Hernandez Viramontes in a vehicle and transported him away. During this time, Hernandez Viramontes did not know whether they were going to take him to a detention center. Agents verified his citizenship and about 20 minutes later brought him back to the car wash. When agents brought Hernandez Viramontes back to the car wash, they did not apologize. Shortly after agents returned Hernandez Viramontes to the car wash, yet another group of agents raided the car wash again. It's pretty bad. Yeah, it's pretty bad. Oh, no worry, Austin Artist. This one might not be for you. Come back another time. I completely understand. In the afternoon of June 12th, Gavidia, a U.S. citizen, was at a tow yard in Los Angeles County that was visited by immigration agents conducting a roving patrol. Around 4:30 p.m., upon hearing someone say the immigration agents may be at the premises, Gavidia went outside to confirm this. At the time, his clothes were dirty from working on his car. On the sidewalk outside the gate, Gavidia saw a federal agent between two cars step forward. Soon after, Gavidia saw several other agents wearing similar vests with the words Border Patrol Federal Agent. He also noticed that the agents were carrying hand GUNSs, and at least two of the agents had military-style RIFLEs. When Gavidia attempted to head back inside the tow yard premises, a masked agent said, "Stop right there." While the agent approached Gavidia, another unmasked agent ran towards him and asked if he was American. Gavidia told the agent he was American multiple times. The agent responded by asking, "What hospital were you born in?" Gavidia calmly replied that he did not know. The agent repeated the same question 2 more times, and each time Gavidia provided the same answer. At that point, the agents pushed Gavidia up against the metal gated fence, put his hands behind his back, and twisted his arm. Gavidia had been on his phone, and the masked agent also took his phone from his hand at that point. Gavidia explained the agents were hurting him and that he was an American. The unmasked agent asked a final time, "What hospital were you born in?" Gavidia responded again. He didn't know. He said East LA. Gavidia then told the agents that he could show them his real ID. The agents had not asked to see Gavidia's identification. When Gavidia showed his real ID to the agents, one of them took it from him. It ultimately took about 20 minutes for Gavidia to get his phone back, but the agents never returned his real ID. Harm to organizational plaintiffs and or their members. So this is where we're going through and talking about the other sets of plaintiffs here. LACIEN is a regional organization made up of 8 worker centers and labor organizations that work together to build power and develop worker leadership organizations with Black immigrant and refugee workers and other workers of color in the Los Angeles region. At least one of LACIEN's members organizations, CLEAN, has been harmed by the ongoing raids in Southern California. Car washes have been a consistent and ongoing target of immigration agents during the course of the raids. At least 24 have been raided so far. UFW's members have been harmed by the ongoing immigration raids in Southern California and fear of being subjected to unlawful stops, arrests, and detention practices in the future. At least one UFW member has been subjected to defendant stop and arrest practices. Again, this is stop and arrest. We're not even doing a stop and frisk. We're just arresting here, which is way outside of the boundaries here. As a result, defendants' actions, Chirla's mission to serve the immigrant community, including through the provision of legal advice and services, is being frustrated. Throughout the month of June of 2025, Chirla's attorneys and representatives have attempted to communicate with individuals at B18, but were denied access and thwarted in their efforts to offer legal advice to even those detainees they saw at a distance. Chirla also coordinates the Los Angeles Rapid Response Network, LARN, and educates its membership as well as the border community through Know Your Rights programming, workshops, social media, and educational literature about a variety of social services and benefits, including immigration law, financial literacy, workers' rights, and civic engagement. Defendants' actions are also thwarting Churla's work to coordinate the LARN, as other attorneys and representatives summoned by Churla to B18 have been similarly denied access. MDEF's rapid response team is also part of LARN with Churla and monitors a hotline and responds to notifications about individuals detained in Cube immigration enforcement actions. As a result of defendants' actions, MDEF's mission to serve the immigrant community, including through the provision of legal advice and services, is fundamentally frustrated. Oh, yikes. All right, here's our procedural history. On June 20th, petitioner plaintiffs filed a petition for writ of habeas corpus. Writ of habeas corpus means bring forth the body, and that is what you file when you're claiming the government has unlawfully detained you and you are being detained. The petition alleged 5 causes of action. 1, warrantless arrest without probable cause of flight risk in violation of 8 U.S. Code Section 1357A2. 2, warrantless arrest without probable cause of flight risk in violation of 8 CFR Section 287.2 sub C sub 2 sub 2. 3, arrest without probable cause in violation of the Fourth Amendment. 4, failure to identify officers and basis for arrest in violation of 8 CFR Section 287.8 sub C23. And 5, violations of due process. Here. On June 20th, petitioner plaintiffs filed an ex parte application and requested the court grant their request for a temporary restraining order. Again, ex parte means only one party is talking to the judge. And enjoined defendants Noam Bondi, Cubes, and Lyons from transferring petitioner plaintiffs outside of this judicial district. The same day, the parties stipulated to withdraw the ex parte application. The court granted the stipulation on June 23rd. Following the magistrate judge's July 1st order vacating status conference, the parties filed a joint notice following order vacating status conference, through which they informed the court that the petitioner plaintiffs' bond hearings were set for July 3rd, July 7th, and July 8th. On July 8th, the parties filed another joint notice following order vacating status conference, informing the court that Vasquez Perdomo was granted bond on July 3rd, and that Villegas Molina was granted bond July 7th. On July 2nd, plaintiffs filed the operative First Amendment complaint. The First Amendment complaint adds as plaintiffs Viramontes, Gavidia, Lon, UFW, Churla, and MDEF. The first AC also adds as defendants Scott Bank, Patel, Santa Cruz Jr., Wang, Bovino, Stalnecker, Davis, and Asali. Moreover, the 1AC contains class actions allegations seeking to represent a class under the Federal Rule of Civil Procedure 23B2, consisting of 3 classes. 199, suspicious stop class. That's reasonable suspicion less. Here. 202, warrantless arrest class. And now, you can arrest without a warrant. You have to have probable cause. That's the thing. And then 205, failure to identify class. Plaintiffs allege the following causes of action. So here's our complaints, our counts in here. Count number 1, violation of the Fourth Amendment, unreasonable seizures on behalf of stop and arrest plaintiffs and suspicionless stop class against all defendants. Count 2, violation of 8 U.S. Code Section 1357, warrantless arrest without probable cause of flight risk. And then we have the defendant or the plaintiffs here, all defendants. Next, violation of 8 CFR 287.8, standards for stops and warrantless arrests. Next, I'm going to just bump down everyone here. We can kind of see the chart. I want to keep moving forward here on the complaint. Failure to identify authority and reasons for arrest. Fifth Amendment, access to counsel. Here, 1362, access to counsel in violation of the Fifth Amendment regarding the access and detention plaintiffs here. Yeah, probable cause, yikes. All right, let's catch these footnotes because this helps explain the law a bit better. The suspicionless stop class is defined as all persons who, since June 6th, have been or will be subjected to detentive stop by federal agents in this district without a pre-stop, individualized assessment of reasonable suspicion concerning whether the person, 1, is engaged in an offense against the United States, or 2, is a non-citizen unlawfully in the United States. See how they split that? Everyone, let me just make sure that we're noting what's happening here. They're splitting this into two categories because we have kind of two different standards. So the first, an offense. So are they actually committing a crime at that moment, right? So this is our criminal one. Or number 2, a non-citizen unlawfully in the United States. Two separate things. Non-citizen who is present here. Two separate things. And that's why we've got some significant issues going on here. Oh yeah, they're still doing all of it. Absolutely. All right, so the warrantless arrest class is defined as all persons since June 6th who have been arrested or will be arrested in this district by federal agents without a warrant and without a pre-arrest individualized assessment of probable cause that the person poses a flight risk. The failure to identify class is defined as all persons who since June 6th have been arrested or will be arrested in this district by federal agents where agents 1 fail to identify as immigration officer who's authorized to execute an arrest and or 2 failed to state that person's under arrest and the reason for arrest after it's practical and safe to do so. So also let's take a minute here and let me just remind everybody, we also have something called Miranda rights, right? And you might say, well, not everybody has Miranda rights. So Miranda rights apply if you've been taken into custody and you're going to be interrogated. All right. If either of these conditions is not met, Miranda is not required. So we're in a situation civilly again where we're talking about a different kind of custody and a different kind of interrogation. So Miranda is not even coming into play in any of these situations. All right. And again, this is that difference between civil versus criminal and defining our words, right? So they're going to say, well, we're not interrogating anybody. So, they're not under arrest for an offense. So we don't have to use Miranda, right? So Miranda v. Arizona set out the Miranda warnings, right? Right, case by case. But technically, if you are in a civil case where you're not being asked to admit guilt, you're being asked for information, is that rise to the level of an interrogation for Miranda, right? Yeah, right. I mean, that's the question, though, is whether or not it rises to that level. And that can be argued. And while it's being argued, a lot of harm can be done, which is really what's happening here. All right, July 2nd, the access detention plaintiffs filed an ex parte application for temporary restraining order and order to show cause regarding preliminary injunctions. Here, the same day, the court ordered the parties to fully brief the access detention TRO by July 9th. I'm going to kind of skip forward a little bit, everyone, here on the procedures so we can get further into the arguments. Here we go. So we've got amicus curiae briefs that were filed, application to participate here by other parties, plaintiff interveners were requested, And then we had the applicable law that's being set out here. Again, if you've been with me for a while, you know we go through the winter factors. There is a test that has to be met in order to have a preliminary injunction. Preliminary injunction is something that occurs before the case even gets going. It's temporary. It's not as quick and exigent as a temporary restraining order, but it's supposed to be temporary until things can get to the judge. All right, so there's a test. If you satisfy the test, you can have an injunction. If you don't, you cannot have an injunction. So the winter's test here, she's setting up. Now, we'll move through that because that's more of a legal analysis here for that injunction. And I want to get into, I really want to get into her explanation. All right. Oh, hold on here, everyone. Skimming through here. Everybody's got standing. That's what she's setting out here. Have established they are likely to succeed on the merits. All right, here we go. So this is really where the next piece is. Can they detain you indefinitely? So good question. That's the other thing too. Oh my gosh, there's so many things, everybody. There's just so many things. If you are arrested, right, and we're in a criminal situation, you have a right to be seen by a judge within 24 hours. All right? That is not the same situation in a civil administrative case. All right? There is no being seen by a judge or the initial appearance, being told what the charges are against you and such. This protection is not applicable here in civil court as of this moment, all right? Who knows? Again, this stuff needs to get hashed out because this gray area that everybody's operating in is atrocious, right? So if you don't say anything and at this point you give no information to them, I have no idea what they're going to do with that. I truly don't, because we're not in a criminal detention situation. We have a deprivation of freedom, so we don't have due process. I mean, we're having a due process issue. And so you have to ask for an attorney, which is important, but you're only going to get the protection of due process under the Fifth Amendment when you're asking for an attorney. P.S. This is not legal advice. So it's a huge question. Again, we're in this gray area where they are manipulating the civil and criminal differences for what's going to work best for them in this situation. You can be arrested for a civil issue. So there is detention piece in the immigration laws. All right. And I'm not an immigration attorney, but there is a detention piece to it. Now, if you think about a civil offense, right? So let's think about that. What would be a civil offense? So let's see. I'm trying to think, like unpaid parking tickets. You might think that that's a civil offense, but that's actually quasi-criminal. So I'm not sure that would be it. Another civil offense. I'm not sure. Jaywalking, that's still criminal, technically. Parking tickets, technically still quasi-criminal. Speeding, that's a scheduled offense usually. Not cutting your lawn, violation of city ordinance. Ooh, that's a good one, Willie B. Let's talk about that. Oh, I've got the puzzle. Hold on, everybody. Wish me luck, wish me luck. Did I do it? Oh, I did it. Yay! Okay, Willie B, you got a good one. Let's do that. So, or sound. How about that? Let's talk about that. Lawn cutting or like a sound violation. All right, so too loud. Are they going to arrest you for that? No, they're going to give you a ticket. They're going to send you in to court if you don't pay the ticket, right? So that's more, I think, of the area that we're talking about here than if we were talking about speeding. And I say that Because if we use the example of speeding here, you can be arrested if you're pulled over, if you're stopped for speeding. You can be arrested. If you refuse to sign that ticket, people usually don't read the fine print on the tickets. I recommend reading it. If you're not signing that ticket, they're taking you downtown, right? Because basically your signature is what is letting you say, fine, I'll take care of it later, let me go now. So you're basically being released on your own recognizance for those kinds of tickets. But if you don't sign it, they're going to put you in the back of the car and take you to jail. That's what's going to happen there. Right, disturbing the peace. Right. Right. Trespassing is a criminal offense. Trespassing is also civil, intentional toward as well. Passing a school bus, interestingly enough, you can actually get charged with a crime, depending on how your codes are written. I think the unlawful passing a school bus was the only case where there was like a citizen's arrest situation that I ever worked on. And I was like, this sucks. This sucks a lot. But yeah. So when we're in this weird world of immigration, and it's its own creature. It's its own creature, because if you're in a place you're not supposed to be, the detention is supposed to put you in outside of the place you're not supposed to be. It's not supposed to be sent to a prison in El Salvador, right? It's supposed to be you are out of the place. And the way it's being interpreted and enforced in this situation is just, if you think about why we put people in jail, it's for public safety, right? Public safety or punishment, right? There's multiple reasons, but if we're punishing someone, that's a criminal situation unless you're getting punitive damages. But if you are trying to protect the safety of the community from someone who's been working in a car wash for 10 years, I mean, are you flipping kidding me on that? That's ridiculous. So the whole gray area to abuse the system, and I tell you what, Pam, that is the goal, that is the theme of this administration. All of those gray areas that as attorneys we were like, all right, this needs to be firmed up someday, because if someone gets into power who is immoral or who is a bad guy or gal, they're going to take advantage. That's where we're at right now. The bad person got into power and taking advantage of those gray areas. So we've got some issues. Why can they retroactively change a decision that's been allowed by a previous administration? I'm not sure exactly what you mean, Heather, other than if there's a policy or executive order from the prior administration, can immediately be revoked by the new administration. Oh, thank you so much. Yeah, these are my California. I feel for you, California. These are my California nails. Here. Right, exactly. So, and that's the thing again. I've been trying to give this scenario out as an illustration of kind of where we're at here in this situation. When you get a restraining order, a court has said, yes, this person's going to cause you harm. So we'll get a civil restraining order. There's no crime, all right? So you have a restraining order. You got to stay away from me. You have the piece of paper, and that's fine. So if someone comes close to you, stands within some area, but not a violation of the no contact order or restraining order. So they have to stay 100 feet away. So now they're 102 feet away, standing there looking at you, freaking you out, and you call the cops. They're like, we can't do anything. Until they cross that line, until they cause harm, we can't do anything. So that's a lot of what's happening right now. There may be legal grounds for bringing these cases to court in various things, but the harm will get done before actual work is done on the situation. Oh, sorry, Doughboy. I just missed your comment. Sorry about that. How can we force release of the files? Of the Epstein files? Good luck with that, right? I really like to touch on debtor's prison idea if possible. So that's a lot, Doughboy. That's not something you can just touch on. Debtor's prison. There's so many different elements to that. Let me write it down and do a post on it. What's the history of that in this country and the ongoing pressure and abuse of the system in order to allow for that is just absolutely atrocious. I agree on that. Oh, sure, you bet. If civil and you've retained an attorney, are they required to allow the visit? That's a great question, Pam. I'm not sure. I'm not exactly sure. Because we're in this gray area, and due process is what's allowing for the attorney, as opposed to a criminal case where you have to have an attorney in that situation. I am not sure what that mechanism is for how far your due process rights under the Fifth go for an attorney in a civil case. I just don't know. I just do not know. Oh, absolutely, Doughboy, absolutely. So it's quite a bit. All right. Sorry, everybody. We were talking about the Epstein. Here, real quick. Yeah. Whoever has access to those files controls how they're released or not released. I mean, Congress came in and said, well, we want to have that information. And that's huge for Congress to come in and pass a law to force the executive branch to give them information. That's crazy town. We're in crazy town. What's happening in Congress? I mean, that's ridiculous. They shouldn't have to do that. They're supposed to work together. But anyway, that's like the last resort. That is the most powerful thing that could have been done to actually try to get those records, would be literally a congressional law situation. And I use that term law as, like forcing someone to come out. Hold on. One quick side note as we go down this real quick thing. Congress does have subpoena power. All of them have subpoena power. They can request documents. They can request testimony. So it's possible for them to put together an investigation of the situation and request testimony of people to come in and talk about it. So that's probably like their strongest sword right now, would be to pull in the people involved in the situation, ask them questions, and request document productions. They can do that. Are they going to? And will it be successful? Don't know. All voted no. Simple majority in committee. Yep. So that would definitely be another option. Although, will it work? Again, we just don't know. All right, everybody. At this point, I'm looking at the clock, and I've hit my max for my voice. So I'm going to have to do a part 2 for this. I can't emphasize how important this is, so I will do a part 2. I need to give my voice a bit of a rest. So let me mark where we stopped here, because again, we've got to get into that legal analysis, and I will pick up here for a part 2 live going through this. I'm not sure exactly when that will be. Forgive me. The latest would be tomorrow. The earliest would be probably later this evening, maybe around the 5 o'clock range. So to give you some idea of what's going to work. So later this evening or tomorrow, I will go through this, the rest of it here. How do we know that said file's not already been... There's no way to know. Yeah, we don't know. We don't know any of that stuff. It took like 80 years to get the Kennedy information. I really don't know. And that's the other thing too, is I'm not sure anything in those files is something that is legally necessary for what's going on. So I'm not saying it's not important or that the public doesn't have a right to that information. But if you look at it from a legal point of view, by releasing that information, I don't know. It could mess up potential future criminal charges, but I think the charges that have come through are probably going to be the last of the charges, honestly. Is that horrific? Yes. Can people sue? I would encourage them to sue. This is a situation where those lawsuits are going to produce more information than our criminal cases here. And that can happen. So that's tricky for sure. Oh, sure, you bet. If they did that though, why not release redacted instead of saying it doesn't exist? Well, still, it's even if you release redacted, even if you just release pages of, an entire page that's been redacted, which is kind of like Nixon, people are still going to be coming in and saying, well, this could be this and that. The American people, let me just do a quick side note here. I know a lot of people are like, you guys are dumbasses, but the American people, we are the curious peoples, and we will figure out a way to try to break through that redaction. So even putting it out there gives this chance of something going out. So I would say it's better to just say, man, we don't have anything, than to put out completely redacted pages, because even that could add to it, could add to the conspiracy. Oh, thanks so much. Yes, my California nails. Whiplash is their well, exactly. And I think they've underestimated how strong the American people are. Like, you said you're going to give us this information. You need to give it to us. Like, we're not playing around. We want it. We want it. Missing minutes in Watergate. Yes, exactly. Missing minutes on the video. And it doesn't matter what they say. It's never going to satisfy the people. And that's just what we are. I mean, we are just incredibly curious, and we will track down information one way or the other. So the information may not be correct, but we're still going to track it down. Oh, that's one thing that we love and hate here. All right, so with that, my friends, I will go ahead and sign off. Thanks for coming and hanging out. Again, I will do a part 2 for this live. We'll finish up the legal discussions and so on. So I will catch you all later, either later today or tomorrow, to finish up. Have a great rest of your day, everyone. If I don't see you, take care.